Can Liberty Mutual legally deny a claim when the sit-to-stand accommodation has been made for the policyholder, but that accommodation doesn't relieve them of their back and neck pain? Did you know that disability carriers justify a claim denial or termination based on the opinions of its liar-for-hire peer-review physicians? The case of McKinnon versus Duke University is no exception. Let's learn what a liar-for-hire peer-review provider said and how carriers and plan administrators use them to terminate legitimate claims. Disability carriers will routinely use staff physicians or nurses or medical providers from third-party companies like MES Solutions, MLS, and Dane Street to review medical records. They create a reason to justify a claims denial or termination. The carrier will use these services at all stages of a claim, including the initial application, to determine the correct date of disability, whether they were disabled at the time they stopped working, whether the policyholder satisfied the elimination period and remained disabled, and as a way to disagree with the policyholder's doctors about restrictions and limitations. There's always in a policy a change of definition of the disability from their own occupation to any occupation. Disability carriers will justify a claim termination on the basis that the policyholder has improved or they can work in a sedentary position. Let me give you an example of how carriers will use the liar-for-hire physician to justify that claims denial. In this particular case, Liberty Life was the administrator of Duke University's long-term disability plan. The plan granted discretionary authority to Liberty to determine whether the plan participant was unable to perform the essential duties of any occupation or could reasonably perform that occupation and become qualified for it by education, experience, or training. Now, normally the discretionary standard of review is a kiss of death. The only way to win is to show that the carrier didn't exercise a principled, deliberate decision-making process required by the ERISA regulations. So what's the first step a disability carrier will take in a claims denial or termination? The first step they'll take is for the disability carrier to disagree with the treating physician's opinions about the policyholder's physical or psychiatric restrictions and limitations. They do that by having an independent review of the policyholder's medical records conducted by physicians whose job it is to create that disagreement. I call them liar-for-hires. In Miss McKinnon's case, a familiar cast of characters determined that she couldn't have any limitations on her ability to sit, stand, stoop, or walk, that she could only stand occasionally, and she could sit and stand at a workstation that could accommodate her impairments. So, as expected, Liberty denied the claim and McKinnon appealed. Now, when Liberty upheld the denial, she filed a lawsuit in federal court in North Carolina. What did that federal judge do? Well, the judge noted that the standard of review was arbitrary and capricious. The judge concluded that the medical and vocational evidence and the ultimate decision by Liberty to deny the claim was not the result of a principled, deliberate decision-making process. What swayed the judge to reverse the denial was the following. It was years of treatment notes of documentation of her neck and back pain that had failed to respond to any type of treatment. There were also detailed medical records documenting her limitations on her ability to sit and stand for any length of time. The objective MRI testing of her neck and her low back established an organic physical basis for her complaints and her restrictions and limitations, and 2 functional capacity evaluations corroborated her complaints of pain, her inability to sit or stand for any length of time, and her inability to sit and stand at will to relieve her pain. The support of her treating physicians was crucial, and there was also a fully favorable Social Security decision awarding her benefits. The judge called out Liberty's peer review providers, those liar-for-hires, for making contradictory statements in reaching opinions about McKinnon's restrictions and limitations. They contradicted themselves. The judge also called them out because they didn't fully consider all of the medical records. They ignored or they dismissed the FCE results, and they stitched together an alleged ability to stand occasionally, up to 1/3 of the workday, and the use of a sit-stand workstation to magically conclude that she was capable of working the whole workday. And the judge took them to task for concluding that prolonged periods of standing relieved her pain caused by the sitting for prolonged periods of time. Obviously, that wasn't supported by the medical. Principled deliberate reasoning process is required. Now, I know it's hard to overcome the arbitrary and capricious standard of review, but one way to do it is to attack the medical and vocational opinions used by the carrier. I take that liar for hire peer review provider opinions apart piece by piece, line by line. I show why these peer review opinions fail and why they aren't supported by the objective medical evidence. Not only must the carrier use a principled process, but one that reflects deliberate reasoning. Relying on unsupported opinions of your liar for hire medical review providers isn't the deliberate and reasoned process required by ERISA regulations. If your claim has been denied or terminated, call me. We'll talk about how we can attack that denial or termination on the basis that your carrier has failed to use a principled, deliberate reasoning process in your claim. Call me today at 727-894-3188 for a complimentary consultation.